The following will be an extended summary of the government's immunity opening brief in Donald Trump's criminal conspiracy case in Washington, D.C. Welcome to Law and Society. Please subscribe. And before we start out, a few housekeeping matters. I will be speaking slowly and enunciating, and this video is going to take some time. And I generally speak kind of slowly. So I would highly recommend that you go to the bottom of the screen on YouTube and you'll see the circle and you click on that wheel and it will, one of those options will be the video speed. Please speed up the video up to 2 times, and that should get you at a pace where you will still be able to understand what I'm saying and still have it not take so much time. Because this video is going to be long, I'm going to do an extended summary, and that leads up to the second housekeeping thing, which is why I'm doing this again. I'm doing this again because, first of all, it was really bad lighting in the first one because of the storm that came through as I was going through it. And secondly, which I think is more important, is I hurried through the first time. And I don't think that I did justice to Jack Smith's brief uh, by just hurrying through it. And I understand that there are a lot of people who don't know the facts or aren't aware of exactly all the facts of what is happening or what has happened and what Jack Smith claimed in the superseding indictment, what happened with the Supreme Court, what happened with the facts of the case. And so I want to sort of read you the extended summary with parts of the factual evidence that we already have read in the superseding indictment. And in the shorter section 2, we will go through what the Supreme Court said in Trump v. United States and how the DOJ, how Jack Smith's team has synthesized that into explaining how to fit that into the analysis of the facts. Now, remember, this is the government's position. The judge can say, no, this is not exactly how I see it. And so please, that answer may come when Donald's lawyers reply to this opening brief and there's that argument happening, and then there's the oral arguments that happen, and then Judge Chutkan rules on what happens with the case. And you can't assume that this brief is going to end up being what Judge Chutkan adopts. It can also be parts of what Donald Trump's brief, countering brief, will have that it will, be part of Judge Chutkan's order. So, I want to get a full understanding out of what is, what the opening brief in the immunity case. And lastly, and this is not housekeeping, this is a bit of gloating. For a long time, we thought whether Donald Trump with his delay tactics would be able to stop every proceeding that is happening against him. He hasn't been able to stop any one of them. They've always all been either paused, they have been dismissed and pending appeal, or in this case, going to the evidentiary hearing for the SCOTUS ordered immunity hearing. And that's what Judge Chutkan is carrying out right now. And Judge Chutkan, because they didn't ask for an order of stay, and because Judge Chutkan didn't agree with Donald Trump's argument that there needs to be further briefing and to keep the opening brief under seal because of further briefing. So that didn't work, and Judge Chutkan released the the opening brief, the immunity opening brief, and it kind of shattered all of Donald Trump's delay tactics over the last, what, 2 years, almost 2 years that this case has been lingering. And I think that that's karma coming through. And I believe that the people have a right to know and a need to know this information because it is important to our democracy. It's important to understand how close we came to losing our republic. It's important to understand that the person who perpetrated these actions, who the government alleges as the criminal defendant in the case, and refers to as defendant every time in the immunity brief, that person is running for president again. And so the threat remains. The threat that was present when the actions that Donald Trump took place 4 years ago, that threat remains alive to this day. And it is our responsibility, speaking politically and speaking from a citizen standpoint, to go out and vote and make sure that that doesn't happen ever again. But today's topic that I categorize as sort of more education than anywhere near news, politics, or blogs, or people, or any of those categories, because it is fundamentally going into the legal argument that the government has presented of what Donald Trump did 4 years ago. So without further ado, I am going into the brief that that Jack Smith submitted and that Judge Chutkan released for public release. It's redacted and there are a lot of names and numbers put to them, and that may get a little confusing, but I will, again, as I said, read slowly. So please speed up the video. If you're watching it live, by the way, I don't think you can speed up the video. So sorry about that. Thank you for being here, though. I really appreciate it. Please stick around and at least part of it. I understand that I'm doing it late in the night for y'all, but I am on the other side of the planet, so I have to kind of do it when the light is good, like I said, because I go with natural lighting. Anyway, with that said, I'll have a quick drink of water and I will get started. The government's motion for immunity determinations. The defendant asserts that he is immune from prosecution for his criminal scheme to overturn the 2020 presidential election because he claims it entailed official conduct. Not so. Although the defendant was the incumbent president during the charged conspiracies, his scheme was fundamentally a private one. Working with a team of private co-conspirators, the defendant acted as a candidate when he pursued multiple criminal means to disrupt, through fraud and deceit, the government function by which votes are collected and counted, a function in which the defendant, a president, had no role. So then Jack Smith goes into saying that he's, sort of a description of what he has done with this brief, which is the first section. It provides, the facts that came upon that the facts involved in the case that is very similar to the superseding indictment. And in the second section, going to introduce a very small section that's going to introduce the law of how it interpreted the Supreme Court's Trump v. United States ruling. Section 3 is the real meat of it because it applies the law from Section 2 to the facts of Section 1 and then comes to the conclusion that it does in Section 4, where Section 4 explains the relief sought by the government and specifies the findings the court should make in a single order, namely that the defendant's conduct set forth in Section 1 is not immunized. So, with that said, I'm going to go into the facts of the case, and we know most of the facts of the case. So, I'm not going to go and read um, every single page of it and every word of it, because I think that certain parts of it are in the superseding brief, and repeating it would be redundant. And I implore you to go and read either the superseding brief or read the uh, redacted opening brief that I'm reading from. That pretty much gives you all the information you need to know about what happened and what the government alleges that Donald Trump did. So I will read in the instance of immunity, in from the perspective of immunity, from the perspective of the brief that is presented for this issue of what is immune as in official or official presidential conduct and what is not. At its core, the defendant's scheme was a private criminal effort. In his capacity as a candidate, the defendant used deceit to target every stage of the electoral process. As set forth in detail below, the defendant worked with private co-conspirators, including several names that are redacted, and private political operatives, more redacted names. I kind of know who these names are, but I'm just going to not try to sort of explore that. I believe that Politico or yeah, no, somebody. It's on my X wall. You can see it. It's sort of an annotated uh, brief of this one, which gives you all the names of who these marked out people are. So you can check that out. It's on my Twitter account, X account. So the formation of the conspiracies. Leading into the election, the defendant's private and campaign advisors informed him that it would be a close contest and that it was unlikely to be finalized on election day. In the months leading up to the election, he refused to say whether he would accept the elections, insisted that he could lose the election only because of fraud, falsely claimed that mail in ballots were inherently fraudulent, and asserted that only votes counted by election day were valid. On October of 2020, this is Steve Bannon, described the defendant's plan and what Trump's going to do is just declare victory, right? He's going to declare victory. And that doesn't mean he's the winner. He's just going to say he's the winner. After explaining that Biden supporters favored voting by mail, Bannon stated further, and so they're going to have a natural disadvantage, and Trump's going to take advantage of it. That's our strategy. He's going to declare himself a winner. So that's sort of, giving the ominous, you know, sort of warning that Steve Bannon gave all of us that we should have heard. And, I believe that the FBI and our national intelligence should have picked up on and started, you know, prepping for what was going to happen, but they didn't. He claimed without evidence or specifically that there had been fraud in the election and that he had won. This is a fraud on the American Republic, on the American public. This is an embarrassment to our country. We were getting ready to win this election. Frankly, we did win this election. We did win this election. And Donald Trump said this at around 2 in the morning, 2:20 in the morning on November 4th. And that's what he doubled down on. And to this day, that's what he has doubled down on. And so Jack Smith goes further into how, you know, this was rigged, because if it was rigged, that's the only way we could have lost this election. So, and then came, I look forward to Rudy Giuliani spearheading the legal effort to defend our right for to free and fair elections. That was a declaration that he made over a tweet the next day. These advisors, including P9, the White House staffer and campaign conduit, and Pence, the defendant's running mate. So the defendant knew that his claims of outcome determinative fraud were false. In a separate private conversation, when that person reiterated to the defendant that Rudy Giuliani would be unable to prove his false allegations in court, the defendant responded, "The details don't matter." In the post-election period, also took on the role of updating the defendant on the near daily basis on the campaign's unsuccessful efforts to support any fraud claims. P9 told defendant that the campaign was looking into his fraud claims and had even hired external experts to do so, but could find no support for them. Donald Trump, it doesn't matter. The truth doesn't matter. And then there was the calls between Donald Trump and Mike Pence on November 9th, November 11th, November 12th, at a private lunch where Pence tried to encourage the defendant on November 16th to accept the results of the election and run again in 2024, to which the defendant responded, "I don't know, 2024 is so far off." Well, just a reminder, people, 2024 is now. So make sure you vote, and make sure you vote blue. Discussions in which Pence apprised the defendant of conversations he had had with governors of Arizona and Georgia in the context of election challenges, in which Pence had called the governors simply to gather information and share it with the president, and in which the governors did not report evidence of fraud in the elections in the states, and explained that they could not take action to convene their states' legislatures. So, Donald Trump started to incite this, "I'm not going to accept it," from the day after the election. At one point, long after the defendant had begun spreading false fraud claims, another White House staffer traveling with the defendant overheard him tell family members that it doesn't matter if you won or lost the election. You still have to fight like hell. The defendant and his co-conspirators also demonstrated their deliberate disregard for the truth, and thus their knowledge of falsity, when they repeatedly changed the numbers in their baseless fraud allegations from day to day. The defendant used lies to inflame and motivate the large and angry crowd of his supporters to march to the Capitol and disrupt the certification proceedings, and everything before that, which we're going to talk about soon. So in Arizona, what he was trying to do shortly after, on November 13th, campaign manager told the defendant directly that a false fraud claim had been circulating, that a substantial number of non-citizens had voted in Arizona, was false. The same day, as noted previously, campaign attorneys concluded in court that the remaining election suit in Arizona was moot, meaning it had already happened, because the claims were false. The defendant and Rudy Giuliani continued to try to influence people in Arizona. For example, co-conspirator 1 tried to contact person 17 on November 22nd, the same day the defendant and Rudy Giuliani reached out to the Arizona Speaker of the House as described below. So it goes into the conversation with Rusty Bowers. The defendant and co-conspirators also attempted to use false fraud claims to convince political allies in the Arizona state legislature to ignore the popular vote and appoint illegitimate electors. That didn't go over too well. On December 4th, Person 18 released a public statement in which he explained that he did not have the authority to use the legislature to reverse the results of the election, and that doing so would constitute an attempt to nullify the people's vote based on unsupported theories of fraud. He conceded that he didn't know enough about the facts on the ground, talking about Eastman, regarding fraud in Arizona, and that person 18 should nonetheless falsely claim that he had the authority to convene the legislature and let the court sort it out. And I believe person 18 is Rusty Bowers, again refused. Person 22 had verified that Rudy Giuliani's claims of more than 10,000 dead voters was false, and that actual number was around 12 and could not be outcome determinative. So that's the claim of dead people voting. Person 25 again forcefully debunked the conspirators' claim about the State Farm video in the press conference on December 7th, explaining at length that the election workers' innocent conduct depicted in the closed circuit camera footage, and stating that what really frustrating is the president's attorneys had the same videotape. They saw the exact same things the rest of us could see. And they chose to mislead state senators and the public about what was on that video. I'm quite sure that they did not characterize the video if they tried to enter it into evidence, because that's the kind of thing that could lead to sanctions, because it's obviously untrue. They knew it was untrue, and they continued to do things like this. So person 26 was just not seeing evidence of fraud in Georgia. That's what I think. That's what one of the election people who came out and spoke out against Donald Trump keeping up these fraudulent claims. Hello, Derek. Thank you for being here. I'm going to take a quick drink of water and then I'm going to go back to it. As I said, this is going to be a long episode, so I hope anybody who comes along, if you don't spend the whole time here, because I understand it's so late, please come back. And when you do, speed up the video, because as I said, I'm going to read through it slowly. So on December 10th, Rudy Giuliani further perpetuated the false State Farm Arena claim when he appeared at another hearing, this one before Georgia House of Representatives Government Affairs Committee. During it, he displayed some of the same footage as had been used in the December 3 hearing, that had been debunked in the interim by Georgia officials and nonetheless claimed that it showed voter fraud right in front of people's eyes. He then named two election workers, Ruby Freeman and Shay Moss, and baselessly accused them of quite obviously surreptitiously passing around USB ports as if they were vials of heroin or cocaine. Not even going to go into the racist underpinnings of that, but that case has been resolved, and Rudy Giuliani owes Ruby Freeman and Shay Moss millions of dollars, which is going to come due soon enough, I hope. So, and suggested that they were criminals whose places of work, their homes, should have been searched for evidence of ballots, for evidence of USB ports, for evidence of voter fraud. As these false claims about these people spread, the women were barraged by racist death threats. So that's the stochastic terrorism playing up, and that's Rudy Giuliani drumming that up. Person 30 had explained in an interview with congressional investigators, this is Ruby Freeman, saying that when someone as powerful as the President of the United States eggs on a mob, that mob will come. They came for us with their cruelty, their threats, their racism, and their hats. They haven't stopped even today. And that's that's unfortunate that that's the reality that they have to live with. And I do hope that they get the money that they have been rewarded by the court because of what Rudy Giuliani did to them. On January 2nd, Georgia State Secretary of State appeared on Fox News and said various rumors of election fraud were false, and the defendant had lost in Georgia. Our office has been very busy with what I call the rumor whack-a-mole. Every day a rumor will pop up and then we whack it down. What we do is we basically whack it down with the truth. And people can't handle the truth sometimes because they're very disappointed in the results. I get that. I voted for President Trump also. But at the end of the day, we did everything we could. We did an audit of the race. President Trump still lost. Then we did a full recount. President Trump still lost. We had a safe and secure process. So, excuse me, and I believe that's this is Raffensperger. And obviously, Donald Trump attacked the Raffensperger. Joint defendant on the call were chief of staff and 3 private attorneys, and persons 36, counsel of record in Trump v. Kemp, and attorneys whom Eastman had emailed about defendant's false verification, and these 2 people introduced on the call as someone who is not the attorney of record, but has been involved. So it's sort of a conspiratorial call that they're all getting in to talk about how they're going to overthrow the will of the people. The defendant raised multiple claims of election fraud, each of which these people refuted in turn. When the defendant attacked person 30, called her a professional vote scammer and hustler, and mentioned her dozens of times through the call, person 33 said that you're talking about the State Farm video. And I think it's extremely unfortunate that Rudy Giuliani or his people then sliced and diced that video and took it out of context. When the defendant claimed that 5,000 dead people had voted in Georgia And the person 33 said, well, Mr. President, the challenge you have is the data you have is wrong. The actual number were 2. So the people that were feeding him the lies and he was believing the lies, mainly it was Rudy Giuliani, because his name is co-conspirator 1 and John Eastman tagging along as co-conspirator 2. And I believe that there's 6 co-conspirators, and I'm not going to be able to place them. Maybe I'll be able to place them with what they're saying, and we'll see. But again, thank you for being here. Hello, HR 1959. I just want to say thank you for being here and listening. I know this is late into the night, and because it's daytime here, I'm going to read this slowly. It's going to take a while. We're at 30 minutes now, and I hope that. Hello, Ray. Thank you for being here. And so I'm gonna have another drink of water, and then I'm gonna get it back into reading the opening brief. The day after the call, on January 3rd, the defendant falsely tweeted, I spoke to Secretary of State Raffensperger yesterday about Fulton County and voter fraud in Georgia. He was unwilling or unable to answer questions such as the ballots under the table scam, ballots destruction, and out of state voters, dead voters, and more. He has no clue. Raffensperger promptly responded in a tweet of his own. Respectfully, President Trump, what you're saying is not true. The truth will come out. Then the defendant issued a false tweet. In Detroit, there are far more voters than people. This is about Detroit. Nothing can be done to cure that giant scam. I win Michigan. So, this is inciting the people in Michigan, his loyal supporters. A person corrected defendant and told him that he had also lost primarily because in 2 routinely Republican counties, the defendant had underperformed with educated females. And if he had received the same number of votes there as the 2 winning local sheriffs, he likely would have won Michigan. So just an off here. If you think that educated females are voted against Donald Trump in 2020, what do you think is going to happen after Dobbs, after Donald Trump takes ownership and is proud to have struck down Roe and caused the deaths of so many Americans that did not need to happen because a third of American states have some form of abortion ban and they are doing restrictive care for women's health. And if you think that women are going to forget that, Donald Trump, you have another thing coming. Notably, the defendant only raised fraud claims to the extent that they affected the outcome of his own race, not those of other offices in Michigan. So everybody else's races in Michigan were fine except Donald Trump's. Days later, the defendant's campaign declined to request a statewide recount in Michigan, for which it would have had to pay unless the recount succeeded in changing the outcome of the election. So this is kind of hilarious because it's a reminder how cheap Donald Trump is. He declined to request a statewide recount because he knew he lost and that he had to repay, and he had to actually pay for that recount if it unless it succeeded. If it had failed, then he would have still lost. It didn't change the outcome. He would have still had to pay, so he didn't want to do the recount. These efforts failed. On December 14th, the day that duly appointed electors across the country met and cast their electoral votes, President 37 and 38 issued public statements confirming that the defendant had lost Michigan and legislators still had not received evidence of outcome determinative fraud in the state. I'm sorry, I'm still laughing about the fact that he just retracted when he realized he had to pay for it. There was, no election fraud was found. Oh man, he's so predictably cheap. Anyway, I'm talking about Donald Trump, everybody. And if I don't see your comments right now, I will comment on it when I take a break for water because this is long, and I'm on 36 pages of 165. Some other people and entities have done full readings of it in a very professional manner. You're not going to get that with me. You're just going to get me reading these briefs and then commenting on it as we go, and perhaps even laughing about the fact that Donald is so cheap. And that's what Jack Smith and his team wanted to convey. I mean, remember that this brief has been drafted by dozens of attorneys who are under Jack Smith's supervision, who have been circulating the brief among themselves and crafting this master document that is going to convey to the American people how ridiculous this is and how much proof there is that Donald Trump defrauded the United States, conspired to defraud the United States, and conspired to defraud the American people and defraud us of our votes effectively. That's what conspiracy to deprive under color of law, conspiracy to deprive rights under color of law. So then we go back to the brief. We are working with the campaign on a data matching project on those numbers and are going to be a lot lower than what Nevada people have come up with. Now we're at Nevada. They are also targeting our military votes. To be frank, the contest has little chance of succeeding. Happy to discuss this stuff with you and more info. Person 44 then sent a copy to person 43 email from her personal account to her personal email account of person 45, one of the defendant's White House staffers who also volunteered for the campaign. So this is how Donald Trump commingled, and we're going to hear about this in section 3. This is how Donald Trump commingled these people and made them do things to further his conspiracy. And that's why these people are not co-conspirators, because they were not in on the big plan that Rudy Giuliani and Eastman and Chesbro were, and Sidney Powell were sort of spinning. These were people who were, unwitting participants who are part of this conspiracy, who were sort of wheels in a huge machine that was operating to create the false narrative that Donald Trump had won. And so that's why they are not co-conspirators. That's why they are, people who are mentioned in the brief, who I believe will very likely be, witnesses and be fact witnesses of what happened when this case goes to trial. Because, I don't see it in these efforts, and we'll read it later on, of being official conduct, because it is not just the nature of the fact that he's president that all his conduct is official. It is the nature of the conduct and the office. So it's specific by conduct. It is not the fact that he is president or the fact that subordinates who tweeted for him, who are appendages of the president essentially, was official conduct. You have to look at the nature of the conduct and see whether it fit into the executive branch duties as put forward in Article 2 of the Constitution. And Jack Smith later on, as we go into Section 3, will say that it does not match up with what Article 2 of the Constitution has specifically divested away from the president, which is everything to do with election of the president. Is delegated it to Congress and the other states. Under Article 2, mind you, that is a presidential limitation put in the article that vests power on the president as the chief executive who embodies a whole branch, who takes care, who is given the responsibility to take care that the laws be faithfully executed. So then we go further back into this. Then there's Pennsylvania. Around the same time, Philadelphia City Commissioner Person 47 appeared on television and stated that there was no evidence of widespread fraud in Philadelphia. After seeing the interview, defendant targeted the Philadelphia City Commissioner, tweeting, "A guy named whoever this person is, a Philadelphia commissioner and so-called Republican, Rhino, is being used big time by the fake news media to explain how honest things were with respect to the election in Philadelphia. He refuses to look at a mountain of corruption and dishonesty. We win." He always sort of ended with, "Ooh, we win." Like, we're just going to believe that. As a result of the defendant's attack, threats that this person already was receiving became more targeted and detailed and included his address and the names of his family members. So I'll take a quick drink of water. And I see you have been talking. So I am not. So hello, welcome, Ray and Derek. Please keep up the conversation if you are engaged by this. I will get back to the thick of your conversation once I finish this brief, and I really appreciate you being here. I also have to ration my water because I have the bad habit of always forgetting to get water before sitting down, because I always misunderestimate, in the words of W. Bush, how long these things are. During the event, Rudy Giuliani falsely stated, and on what event? November 25th event. So this is one of many times it falsely stated that Pennsylvania issued 1.8 million absentee ballots and received 2.5 in return. False. When one campaign staffer wrote in an email that Rudy's claim was just wrong and that there was no way to defend it, person 3 responded, "We've been saying this for a while. It's very frustrating." Likewise, in late November or December, person 9 informed the defendant directly that a claim Rudy was spreading that Pennsylvania received 700 more mail-in ballots than were mailed out was bullshit, and explained the error. So this is showing that he had been told. It's setting us back. Wait, where are we now? Yeah. I'm really not trying to give you a hard time. This is a conversation between person 12 and Rudy Giuliani. About what person 12 and Rudy Giuliani are doing is a joke and are getting laughed out of court. So I think this is person 43 talking about it. It's setting us back in our fight for election integrity, and they are misleading millions of people who have wishful thinking that the president is going to somehow win this thing. So the knowledge of this being bogus was rampant. This is going to Wisconsin now. On December 14th, Wisconsin Supreme Court rejected the campaign's election lawsuit there. In response, defendant issued a series of tweets attacking person 49, the Wisconsin Supreme Court justice who had written the majority opinion. 2 years ago, the great people of Wisconsin asked me to endorse a man named person 49, for state Supreme Court justice when he was getting destroyed in the polls against a tough Democrat candidate who had no chance of losing. After my endorsement, person 49 easily won. Wow, he just voted against me in a big court decision on voter fraud, of which there was much. Despite many pages of dissent from three highly respected justices. One thing has nothing to do with another, but we ended up losing 4-3 in a really incorrect ruling. So passive aggressive here. Great Republican, great Republicans in Wisconsin should take these three strong decisions in their state legislatures and overturn this ridiculous state election. We won by a landslide. I mean, this is Donald Trump. Reading his words is just like almost blasphemy, you know? So after the defendant's tweet, state marshals responsible for person 49, being the justice from the Supreme Court of Wisconsin, safety arranged to provide this justice with additional police protection based on social media traffic and other threatening communications. So now we go to the factual facts of the voting machines. Throughout the post-election period, the defendant, and so that's different than what he was trying to do in each of the states about talking about how the votes were fake. Understand that this is categorical. Like he tried every single way. And these are extrajudicial. These are the illegal conspiratorial ways. He exhausted the legal ways sometime in the middle of December, and he had been informed about that. And we find that out in this brief. And what I'm reading is spotty from each of it because Jack Smith has to go through the fact process of each of these things to say, no, this is not immune. No, this is not immune. No, this is not immune. And it's repetitive. And this is what Donald Trump is putting us through. This is what the taxpayer is paying for. And this is another reason why I want Americans to read this brief, which I have provided a link to in my description box. If they don't have time to read the whole brief and read the legalese and go through this like I'm hopping through this, then you can read this description. You can also read descriptions that others on YouTube have provided. Match it up with the version that is the written brief that has been published. And again, the link is in the description box. So now we're going to go to voting machines in multiple states. So addition to claiming that, you know, he got more votes and these votes were dead voters and this and that, there was also this attack on the voting machines. And as we know, in the years since this fraud, that blaming of Dominion got a nearly $1 billion judgment against Fox News for spreading those lies. The defamation case against Fox News. I mean, Fox News, they probably paid Dominion already by now. If not, that's pending. So this is the machine. Throughout the post-election period, the defendant and co-conspirators repeatedly made claims about the security and accuracy of voting machines across multiple states, despite the fact that they were on notice that the facts were false. As early as November 12th, for instance, the National Association of Secretaries of State, there's National Association of State Election Directors, and other coordinated federal, state, and private entities issued a public statement declaring that the 2020 election was the most secure in American history. And that there was no evidence that any voting system deleted or lost votes, changed votes, or in any way compromised. Election security experts concluded that claims of computer-based election fraud either have been unsubstantiated or are technically incoherent. On November 22nd, notwithstanding the defendant's tweet from 8 days prior announcing co-conspirator three's involvement, Rudy Giuliani issued a statement on behalf of the campaign distancing the defendant from co-conspirator three. Co-conspirator three is practicing law on her own. I think this is Sidney Powell. She is not a member of the Trump legal team. She is also not a lawyer for the president in his personal capacity. Nonetheless, the defendant continued to support and publicize Sidney Powell's knowingly false claims. So contextually, you realize that co-conspirator three is Sidney Powell. If you've been keeping up with, if you've read the brief, or if you've been keeping up with the facts for the last how many ever years it has been, and it's surreal for me because it's like a time warp. For people like me and you people who are here now and who are going to listen to this video, thank you for your dedication to learning the truth about what Donald Trump did. And I hope you share this with others, or share whichever other version of this summary that you find more informative. Share it with others. And if they've read the whole thing, it's great that they have done so. I'm just not reading all of it. I'm just hopping through parts of it that struck out to me. The defendant again promoted the lawsuit in a tweet. The lawsuit was dismissed within 2 weeks on December 7th. So this relentless effort. On December 1st, Attorney General Person 52 stated publicly that the Justice Department had no evidence of fraud sufficient to change the election results. With respect to voting machines, he said, there's been one assertion that would be systematic fraud, and that would be the claim that machines were programmed essentially to skew the election results. And the DHS and DOJ have looked into that, and so far we haven't seen anything to substantiate that. So that I think that is Bill Barr coming out, and Donald Trump was not happy about that. At the ellipse on January 6th, the defendant and co-conspirators who spoke at the rally continued with the unsubstantiated false claims about the machines, Dominion machines. Co-conspirator one, Rudy Giuliani, claimed that in the U.S. Senate runoff election in Georgia the day before, the votes were deliberately changed by the same algorithm that was used in cheating Trump and the vice president. So sort of perpetuating this lie and making it broader. Campaign. So the defendant, his campaign, and their allies had lost or withdrawn one election lawsuit after another in the 7 targeted states. So it's not like they didn't try in the legal way by going through it through the courts and presenting evidence of the fraud that they were claiming existed. And wherever they tried to show it to the court said that, no, we don't see the fraud that you are talking about. Co-conspirator 5 revealed this obstructive plan in 2 additional memoranda dated December 6 and December 9, which proposed that defendants' elector nominees in 6 of the targeted states meet on December 14th, sign fraudulent certifications, and send them to the vice president to manufacture a fake controversy during the January 6th congressional certification. So the following day on evening of, so it's, I'm skipping to evening of December 7th, Rudy Giuliani and Person 39 sent a text message to Person 39 stating in part, I have lawyers assigned in each state working on December 14th electors meeting and what they need. I will send you a list. The defendant's co-conspirators worked in his campaign staff and used his pre-election campaign apparatus to execute the fraudulent elector plan. Campaign staff and agents helped carry out co-conspirator 5's plan. I'm wondering if that is Kenneth Chesebro. I think so, because the fake elector plan is Kenneth Chesebro's plan. Co-conspirator one, Rudy Giuliani, generated direction at Rudy Giuliani's direction. Kenneth Chesebro generated directions to electors in all the targeted states except for Wisconsin, which had already received his memos. So yeah, this is Chesebro. And New Mexico, on how best to mimic a manner in which valid electors were required by state law to gather and vote, along with fraudulent certificates of vote for the defenders' electors to sign. In general, the co-conspirators deceived the defendant's elector nominees in the same way the defendant and co-conspirator 2 deceived person 39 by falsely claiming that their electoral votes would be used only if ongoing litigation were resolved in the defendant's favor. That never happened. But they were told, even while knowing that they were not working, they were told that they would be used only if the litigation succeeded. And then they used it anyways. Other electors who participated based on the conspirators' false assurances that their votes were only a contingency were later surprised to learn that they were used on January 6th and would not have agreed to participate if the conspirators had been truthful about their plan. So obviously, Jack Smith has talked to these people. Ultimately, the Pennsylvania electors insisted upon using conditional language in their elector certificates to avoid falsely certifying that they were duly appointed electors. And in New Mexico, the state that Chesebro's memoranda did not even address, the defendant's campaign filed a pretextual lawsuit just minutes before fraudulent electors met. So there was litigation pending at the time of the vote. So think about that. It's like you're doing legal things to work into a conspiracy, but you're doing these legal things as candidate because the president has no role in going into the voting matters and in election matters. It's just not, it's not constitutional. And it doesn't get into, it doesn't, and we'll see that in section 3, Jack Smith saying that it doesn't really affect the executive branch's functions to incriminate and to incarcerate, to try, incriminate, and incarcerate this person who committed these private acts that were not even in the outer perimeters of presidential duty. Quick drink of the last water I have. There's probably another half cold. So, notwithstanding obstacles, the defendant and his co-conspirators successfully organized his elector nominees and substitutes to gather on December 14 in targeted states, cast fraudulent electoral votes on his behalf, and send those fraudulent votes to DC. When she received, so this is, I think that person 39 may be Ronna McDaniel. When she received an internal RNC email titled Electors Recap Final, which summarized the day's activities, with respect to electors and included a list of 6 contested states in which the defendant's electors voted. She forwarded it to the defendant's executive. Person 42 responded, "It's in front of him." So these people were being used. These people were being used by the co-conspirators to show, to communicate and sort of pass on, sort of be their pigeons, so to speak, trained pigeons. No, they were trained pigeons, but unwitting. They were trained to do their job. They weren't trained to be part of a conspiracy that they weren't told the truth about. On December 13, Chesbro sent Rudy a memorandum that envisioned a scenario in which Pence would use the fraudulent slates as a pretext to claim that there were dueling slates of electors for the targeted states and negotiate a solution to defeat Biden. On that day, the defendant resumed almost daily direct contact with Bannon, which is person 1, who maintained a podcast that disseminated the defendant's false fraud claims. On December 14th, Bannon podcast focused on spreading lies about defendants' fraudulent electors, including the false claim that their votes were merely a contingency in the event the defendant won legal challenges in targeted states. So, the huge conspiracy that was used. Steve Bannon is not a co-conspirator because he wasn't spinning the wheel, but he is person 1 because he is important enough that he was always around Donald Trump. So I'm not sure that, and it's so peripheral. Bannon is so peripheral with his podcast and his contact that it's difficult to catch him as a co-conspirator. I don't know what Jack Smith's plans are with Bannon, but we shall see. Currently, Bannon is in prison until November 1st because of refusing to comply with a congressional subpoena. He's so smart that he completely shot himself in the foot by trying to delay his contempt hearing, and then it fell at a point where he was sentenced during election season. So he'll have 6 days. He'll have 5 days to get his, himself in order to have his podcast. Maybe more. No, 5 days, because he gets out on November 1st. He's at least going to rest a bit. Then November 2nd, 3rd, 4th, 3 days. Yeah. As late as early January, the conspirators attempted to keep the full nature of the fraudulent elector plans secret. On January 3rd, for instance, in a private text message exchange, co-conspirator 6 wrote to co-conspirator 5, Chesbro, "Careful with your text on text groups. No reason to text things about electors to anyone but Eastman and me." Chesbro responded, "K." I don't know who co-conspirator 6 has followed up. "I'm probably a bit paranoid. Haha." Excuse me. Chesbro wrote a valuable trade. Co-conspirator 6. Haha. Then we go to defendant attempted to persuade Pence to reject votes cast by duly appointed electors and choose defendants' fraudulent ones. As the defendant's various attempts to target the states failed and the January 6th congressional certification approached, the defendant co-conspirators turned their attention to Pence, who, as president of the Senate, presided over the certification proceeding. So it was just jumping onto the other plan. Co-conspirator 2, Eastman memorandum stood in stark contrast to concessions he had previously made. So this is him talking to Pence about Pence's, Pence being able to do this and stop the certification. But Eastman himself had written a memorandum in stark contrast where he had previously made about the vice president's lack of authority in the certification proceeding. 2 months earlier, on October 11th, he had written to a colleague that neither the Constitution nor the Electoral Count Act provided the vice president with the discretion in counting of electoral votes or permitted him to make the determination on his own. So, again, they have knowledge of this. Then on December 25th, Chesbrough proposed in a text message to Eastman and co-conspirator 6 that Pence permit an unlimited filibuster of certification in violation of the Electoral Count Act and ultimately gavel in the defendant as president. Just openly conspiring. The courts are bad. FBI and justice didn't do their job, and the US election system looks like that of a third world country. And this is Donald Trump's tweet, I think one of his other tweets, tirade tweets. Freedom of the press has been gone for a long time. It is fake news, and we have big tech with Section 230 to deal with. But when it is all over, in this period of time, it becomes just another ugly chapter in the country's history. We will win. Of course, Donald Trump couldn't possibly be part of the brief. So, within hours of the call with Pence, defendant reminded supporters to travel to Washington for the certification proceeding, tweeting, "The big protest rally in Washington, D.C. will take place at 11 a.m. on January 6th. Details to follow. Locational details to follow. Stop the steal." So using Twitter, and we talk about using Twitter both in his official capacity and in his private capacity. And I've said before, and this is pointed out in Supreme Court opinion in Trump v. United States on page 15 of the slip opinion currently, that talks about it is the conduct that you look at. It is not the person who is communicating. What is the essence of the conduct that you look at? What is the content, the context, and the form of that conduct? On January 3rd, the defendant again told Pence that at the certification proceeding, Pence had the total absolute right to reject electoral votes and the ability to overturn the election. Pence responded that he had no such authority and that a federal official and that a federal appeals court had just rejected a lawsuit claiming that claim the previous day. Then defendant took to Twitter again to falsely claim that fraud had permeated the election. He used his Twitter account as a campaigner when he was doing this, by the way. And that's just an offshoot of me telling you. And, Jack Smith points it out as we go through the rest of the brief. No one from the defendant's White House counsel attended one of the meetings that they had, which I believe was sometime in December, I think December 19th. I think that was the text date. Nonetheless, the defendant repeatedly expressed a preference for Pence's unilaterally reject valid elector votes. Then there was a speech in Dalton, Georgia. He said they are taking the White House. They're going to fight like hell. We are going to fight like hell. I tell you right now, and reminded, I hope Mike Pence comes through for us. I have to tell you, I hope that our great vice president comes through for us. Of course, if he doesn't come through, I won't like him quite as much. He also used the Dalton campaign speech as a call to action to his supporters, telling the crowd, if you don't fight to save your country with everything you have, you're not going to have a country left. So the alarmism is at its peak. It's at its peak, and I'm at 68 pages. Thank you for being here. Marianne, thank you so much for being here. And thank you for having the conversation going. I am going to have my last bit drink of water. And I think because I'm on page 68, I'm going to stop with the factual proffer of section 1 and then do a part 2 where I go over again, as I did with the dark video initially. I think it's important to break it up into two. And also, truth be told, I forgot to get water and I'm parched. So thank you for being here. And I will be drinking some water. Again, the version that is available on it's in the description of this video, this live stream. There is a link that takes you to the redacted version of the brief. Now, on my wall on X, there is another sort of annotated. Uh, um, Thank you, Mary. I try to make it simple. I try to not go into the minutia. So I'm glad that it helps you out. So thank you for being here. I'm going to go and read through the. I think I'm going to end the facts, and then I'm going to um, uh, sort of stop this video. Let's see what's more. I'm kind of skipping and hopping. At 10 p.m. that night, the defendant issued the public statement in which the vice president and I are in total agreement that vice president had the power to act. A statement the defendant knew was a lie from Pence's repeated firm rejection of his efforts, but gave false hope to the defendant's supporters arriving in the city at the defendant's request, and maximized pressure on Pence. So he kept on lying about Mike Pence and priming his supporters to believe that Mike Pence was capable of doing it, capable of doing what needed to be done to sort of steal the election from the people. Defendant set into motion the last plan in furtherance of his conspiracies. If Pence would not do as he asked, the defendant needed to find another way to prevent the certification of Biden as president. So on January 6th, the defendant sent to the Capitol a crowd of angry supporters whom the defendant had called to the city and inundated with false claims of outcome determinative election fraud to induce Pence not to certify the legitimate electoral votes and to obstruct the certification. So it's important that we learn about these facts. The defendant also lied to his rally supporters when he claimed that certain states wanted to reconsider or recertify their duly appointed electors. In response to this lie about Pennsylvania, the defendant's crowd began to chant, "Send it back, send it back." The defendant galvanized his support by painting the stakes as critical and assuring them that history was going to be made. He made clear that he expected his supporters to take action, telling them regarding his loss of the election that we are not going to let that happen, calling on them to fight and to take back their country through strength, while suggesting that legal means were antiquated or insufficient to remedy the perpetrated fraud. Because when you catch somebody in a fraud, you're allowed to go by very different rules. That's what he said. No, Donald, you don't get to go by very different rules. You get to go by the same rules, and hence we are where we are. So now this is on January 6th. Beginning, at 1:30, defendants settled in the dining room of the Oval Office. Much of the crowd wearing clothes and carrying flags evidencing these allegations to the defendant. allegiances to the defendant, not allegations. The defendants issued the incendiary tweet about Pence despite, as he would later admit in an interview in 2023, that his supporters listened to him like no one else. 1 minute later, the Secret Service was forced to evacuate Pence to secure the location. At the Capitol, throughout the afternoon, members of the crowd chanted, "Hang Mike Pence. Where is Pence? Bring him out." And "Traitor Pence." Several rioters in those chanting crowds wore hats and carried flags evidencing their allegiance to the defendant. After rioters had forced their way onto restricted Capitol grounds and past the temporary barriers, including layers of snow fencing and bike racks, they attacked the law enforcement officers trying to protect the building with flagpoles, bear spray, stolen police riot shields, and other improvised weapons. Of his time defending the Capitol, one Metropolitan Department police officer said, "I feared for my life from the moment I got into that. We were walking into the crowd when the Capitol police officer was leading us into the front line. And especially when I got sprayed in the middle of the crowd, I, at that point, honestly thought, this is it. Yeah, multiple times, we're getting pushed, kicked, people were throwing metal bats at you and all that stuff. I was like, yeah, this is fucking it." I mean, that's horrifying. This wasn't, Donald Trump set it up to happen. In the years after January 6th, the defendant has reiterated his support for and allegiance of rioters who broke into the Capitol, calling them patriots and hostages, providing them financial assistance, and reminiscing about January 6th as a beautiful day. I'm calling you because I want to discuss with you. So while factual, sorry, jumped here because I jumped. So while this was happening, while the insurrection was happening, while Congress was on lockdown, Rudy Giuliani was busy calling members of Congress, trying to get them to delay the certification even further. I'm calling you. This is Rudy Giuliani. I'm calling you because I want to discuss with you how they're trying to rush this hearing and how we need you, our Republican friends, to try to just slow it down so we can get these legislators to get more information to you. And I know they're reconvening at 8 tonight, but the only strategy we can follow is to object to numerous votes and raise issues so that we can get ourselves into tomorrow, ideally until end of tomorrow. I mean, how much more specific can these things get? John Eastman, who earlier that day wrote to Person 28 that the siege is because you and your boss did not do what was necessary, probably one of the election officials, emailed Person 58 and again urged him to convince Pence to violate the law, writing, "I implore you to consider one more relatively minor violation of the Electoral Count Act and adjourn for 10 days to allow the legislature to finish their investigations, as well as to allow a full forensic audit of the massive amount of illegal activity that has occurred here." So mind you, this is all extrajudicial. And the only way, and the only way that it was possible is by going about it the wrong way. And this is the factual truth. At 3:41 on January 7th, the president of the Senate, Pence, counted the certified electoral votes and the 2020 presidential election in favor of Biden. So despite everything that Donald Trump tried, Donald Trump failed. And that's the end of the factual proffer of this case. There are so many of you here. I'm not used to people talking so much. Thank you all so much for being here. I am parched, and so what I'm going to do is I'm going to come back and talk about the legal and then apply the legal to the facts, which is what I did in the when I it was darker. I want to just do that more and read more portions of it, so it's a fuller um, understanding of how uh, the you know the brief is and how well written it is. Uh, so thank you so much, and thank you so much, and I will talk to all of you soon. If you're back when I do the other version, that's awesome. If you go to sleep, thank you for being here. Please like, share, and subscribe, and I will see you all. Derek, Mary, Ray. Yeah, I gotta drink my water. So thank you very much, and I'll talk to you soon.